Assalamu alaikum wa rahmatullahi wa barakatuh. Alhamdulillahi rabbil alameen wa salatu wa salam ala rasulil ameen. Amma ba'd, brothers and sisters in Islam, Assalamu alaikum wa rahmatullahi wa barakatuh. I thank Allah subhanahu wa ta'ala that He gave me the opportunity to work on this project since 2010. This is 2018, approximately over 7 years to work on one topic, inheritance in Islam, al-wasiya or Islamic will. What you're going to see right now is just an overview of my work, which I work with the scholars in the USA and lawyers in order to make sure that our will compatible with Islamic law of inheritance. Also, it is compatible with the state laws, in this case, Maryland laws. And if you need the detail, there are 68 question and answer in the book. And this book will give you much more detail than what I'm about to show you. So it's 240 pages of the book that has most of the questions that you have, inshallah. So let me start it. This might take about 30 minutes, then we'll give you a chance to ask the question, but I request you to hold the question towards the end. The reason being is that some of the question will be answered in the presentation itself. And if it's not answered, then we will do it after the presentation. Basically, what I'm going to do is to cover the 5 questions. And the 5 questions are as listed in there. First of all, is it mandatory to have a will? Is it something commanded in the Quran and the Sunnah? Is it something that the Sahaba always did it? And the second thing we talk about is if you don't have a will, what's going to happen to your wealth, your estate, your assets, your money, your wealth, everything, what's going to happen then? The next thing is what is the Islamic law of inheritance? It's a very comprehensive and elaborate system, and it's not easy for the ordinary people to be able to comprehend it. What I have done to take that comprehensive model, break it down into its smallest integer, and then synthesize a simple model that I will show you. And this simple model is good enough for 95% of the people, inshallah. Then we will go and talk about the fourth one, the conflict between Islamic and the state laws. This is where I spend most of my time in 7 years, because they are not compatible. The state laws goes to the left and inheritance laws goes to the right. And how do you make them compatible? Because if you conflict the Islamic law, then it's not the Islamic will. And there is a conflict with the state law, then the state will declare it an invalid will. So that is a big, big challenge. But Allah has helped me, and the scholars have guided me. In consulting with the lawyers, I was able, alhamdulillah, to make all of the conflict resolution and have a will. You're going to have a lot of wills, but we'll talk about our will only this time. The last portion of this presentation, the 5th question, is how do you write one? Where is the template? Which is, you can take it and fill in the information, have witnesses sign, and you're good to go, inshallah. So let's talk about the first thing, and this first thing is that thing is too far away, that's why it's not working. Is any, Brother Saad, is it possible if you can bring my laptop over here, because it has a long enough wire, and then leave the projector there? Because then I have to look back at the screen, because I don't know what's in the screen on my back. Yeah. But there is a long enough wire there. No, no, it's a long enough wire. You can bring it here and I can control it.
Let's put it there. The reason is because the wire has
It's on this side.
okay. That's good.
So the first question that we have here, the first question is it obligatory to have a veil in Islam or not? To my experience, that I met a lot of people across the United States, I found that they are not even aware of it, that they should write a will. So now, the first thing is that this inheritance in Islam in the Quran did not come out like other commands. It came in 3 stages. The first thing is that the Muslims are told, Kutiba alaykum. That means it is obligatory on you, like Kutiba alaykum siyamu kama kutiba alal lazina min qablikum. So it becomes mandatory to have something whenever the word Kutiba is written there. So when the death approaches you, you should have a will. Now lots of people say, well, I'm not old enough, so the death is not approaching me yet. Well, that death can approach you anytime. People die at a young age, in accident, in sickness, and everything. So you should not wait until you get 60, 70, 80, and then say, okay, the death is approaching me. That's not what it meant. So you leave, and it says only very simple thing that you should have a wasiyah. And this wasiyah gives a share to the parents, mother and father, and it gives it to the close relative. Allah subhanahu wa ta'ala did not elaborate in this ayah from Surah Al-Baqarah, number 180. Then the second ayah came, and this is, in Surah An-Nisa, number 7. That is breaking the deep-rooted injustice to the woman before Islam, at the time of Jahiliyyah, before Islam. And deep-rooted things were that the women didn't get any share, whether their mother, their wife, or their sisters, or whatever. So Allah subhanahu wa ta'ala says in here, there is a share for a man and there is a share for a woman. And again, Allah subhanahu wa ta'ala didn't say how much the share should be distributed. Finally, it came in Surah Nisa, ayah number 11, 12, and 176, that share by name and by fractions are already laid out. The Muslims have no control over it to change what is in the Quran now. You have to distribute according to what is stated there. And there's a lot of people who say, I'm going to go get a will and some lawyer will write it to me and I'll pay them $200-300 and they will say when you die everything goes to your wife and children. That is un-Islamic. That is not acceptable. And I'm going to show you in a way the punishment for not writing a just will, what's going to happen to those people. So now, beside the Quran, we have Prophet ﷺ saying, and it's reported by Abdullah ibn Umar radiallahu anhu. He's also known as Ibn Umar, the son of Umar ibn al-Khattab. And he says that it's not permissible for a Muslim who has something to leave behind, that he should not sleep more than 2 consecutive nights without having a will written and beside ready to him, narrated in Al-Bukhari and also At-Tirmidhi. These are Sahih Hadith, so you know that there is no conflict of opinion of the scholar on them. Then we have will in itself is going to protect you in these 6 different ways. The first thing is going to protect yourself. Why is it going to protect yourself? Because when you fulfill the commands of Allah and His Messenger, then you're protecting yourself, because there will be no question in the hereafter if you already did your will according to the Sunnah and Sharia. The second thing, you're going to protect the family, because if you have a will, the court cannot decide who's going to get what share, and share that Allah has indicated in Surah An-Nisa will be distributed. The third thing is that you protect your children. They are under the minor age of 18. Then you assign the guardian in your will. And when you do that, then the state cannot interfere it. Your guardian will be the one you select very carefully. In my book, there is a chapter about selecting a guardian. So you read that carefully before you make a decision who should be raising your children. Should something happen to you and your wife, or the couple, or the parents, then you should protect your body. Once you're dead, it doesn't mean that you can be mutilated and cremated and have autopsy and embalmment and all that kind of thing is not allowed in Islam, is against that. Then you fulfill the obligation. Many times in our life, we are not able to do certain things, and those certain things could be that you miss the fasting during the Ramadan. So you can make it up later, but there are people who have the condition that they cannot fast because they are diabetic, and if they do fasting, it will become threatening to their life, so they give a fidya to siyam. So if you're haven't done the fasting, you put it in your will, so it will take care of it when you die. Then the last thing is you protect your future. The future is what? Future is not in dunya. Future is not tomorrow or next month. Future is al-akhirah, hereafter. That is the future. We are here to win successful admission to the paradise in the future, in the day of judgment. That's what it is. We have the last chance before we die to do something for ourselves. I know all of us work hard and make our needs, paying and taking care of the family and paying bills and everything, but what do you want to do for yourself that is exclusively for yourself and nobody else? And it doesn't cost you any money to do that kind of sadaqah jariyah. So you indicate 1/3, maximum 1/3, you can give it away to those people who are not getting a share from, as indicated in the Quran. So I'll tell you the hadith, that why 1/3 came from. Sa'ad ibn Waqqas radiallahu anhu got very sick at one time. The Prophet ﷺ came to visit him. And Sa'ad radiallahu anhu said, Ya Rasulullah sallallahu alayhi wa sallam, I am about to die. I have only one daughter. I want to give everything I have as a sadaqah. The Prophet ﷺ said, no. So Sa'ad says, Ya Rasulullah, how about 2/3? The Prophet says, no. Then it says, how about, 1/2? And he says, no. Then he came down finally to 1/3, and the Rasul says, okay, even though it's too much, but it's okay. The reason is that he doesn't want people to give everything away in sadaqah, leave it for the relatives so they will not be poor and begging to others. And this is part of the hadith, by the way. So we know that maximum allowed under our control is 1/3. It's optional. You don't have to give anything, but encourage you to give something out of 1/3 because that's going to be exclusively for yourself. And you're not going to take that 1/3 with you, with us in the grave anyway, so why don't you do something that will be benefit in the hereafter, inshallah. So based on that, we know that the 1/3 maximum can be under our control and 2/3 will be distributed as is stated in the Quran. Understand the importance of will that I pulled it out from the Sahasita. In this particular case is if somebody writes a just will. A just will is according to what Allah has stated in the Quran and what Prophet ﷺ has told us. So a man who a good deed, evil for 70 years, and then he does it will correctly, then Allah's Messenger said that his deeds will make him enter the paradise. Quran, Surah Nisa, verse number 13 also said the same thing what the Prophet says. You know that the Quran and the Sunnah go hand in hand. The Quran is the commandment, Sunnah is the explanation of what's in the Quran. Then what happens if somebody has an unjust will? If somebody does for 70 years some good deeds, and at the time of the death, he messes up or she messes up, then his evil deed will make him enter the hell. We should take these warning very seriously. It is not something that we say ignore, it is not going to happen to us. Everything that Allah as His Messenger has said, it is very clear to us now. And Surah An-Nisa, verse number 14 says the same thing. So the question comes, what happens if we die? The most important part is, no matter what happens, you should have a will. If you don't have a will, the state intestacy law will apply and probate court will take over. So without the will, what will happen? The state takes your wealth and they distribute according to the predefined formula. That doesn't mean it will follow the Quran. Like the Quran says that the son's share is double of the daughter. They're not going to follow that. So that is very scary to see that all your wealth is going against the Islamic law or Sharia. Then you have non-Muslim who might become the entitlement to the wealth, which are not allowed in Islam. And again, we know that the bequest is the last thing you can do to give a charity to this masjid in your wasiyah, or give it to an Islamic school, or give the organization that are working for Muslim in this country, like ISNA, ICNA, CARE, Muslim Defense League. All of those people are working, and that's going to be a kind of sadaqah jariyah for you people, inshallah. If there are no relative, then Uncle Sam says, I am the relative, I'll take all the wealth. And if you live in Canada, by the way, my book also contains the Canadian law of inheritance in there. So it is for North America, USA and Canada. So there they don't have Uncle Sam, they have crown. The British crown, the Queen, the government takes all of it. The probate court is one thing they do is to validate your will. They want to know whether the will is according to the state law. They do not care if it is according to the Islamic law. No, they're going to look at the state law. And if it is valid, then a person that you mention in your will, called the executor of the will be appointed legally to now dispose of whatever is stated in the will. And there is like collecting and protecting and paying all the debt and obligation, taxes and all that thing. Sometimes there is a little bit confusion about the type of will, and people usually do not understand the differences. So your last will is the one we're talking about. It's called al-wasiyah, in Islamic terminology. The living trust is another way of writing your Islamic will. A trust is an entity, just like a person. You transfer all your assets to the trust, but you have the control over the trust in your lifetime to do whatever you want with it. But after you die, the trust becomes irrevocable. However, I have advised the lawyers who do the estate planning that make sure the Islamic things are in the trust, so the property will be distributed according to the Quran and Sharia and not according to the state lawyers. The last thing is called living will. The name says living, that when we are alive. But when we are alive, we may get sick, okay? We may get hospitalized. We may be on a life support system, and we're not able to make our own decisions, so you have nominated a person who's going to make your health decision when you are not able to do it. Now, this is a very high-level overview of the law of inheritance in Islam. We look at the whole view, you're going to find there is a deceased on the top, right? And he has some wealth. Then number one is that your liabilities, your debt has to be paid first. And in a minute I'm going to show you a few slides. If you do not pay your debt, what's going to happen to you at the time of the debt. Then second thing, optionally, if you have stated in your will that you want to give some money to this organization, this masjid, this school, or other Islamic organization, that's going to benefit you in the hereafter, because that's your last chance. When you die, there's nothing going to benefit you except your deeds, whether good or bad. And the last thing is that, by the way, the wasiya can go to the individual. Those who do not get the share, you can give them the share. So some condition that you have a son who get the share, but the son's children do not get it, because in the presence of son, the grandchildren don't get anything. So, but if they are poor, you can give it them from the 1/3. And then the remainder will be according to what Allah has stated, not under our control. This is a priority. Expenses for your medical bill if you're in hospital and other things, you do that. And then you pay all your debt. We live in a community or a society in a country where everybody is up to their neck in debt. Loans, debt. And we're going to show you how many different kinds we have and what the consequences of that will happen to us as a Muslim. Then you pay your religious obligation if you have missed the fasting or you have missed the Hajj or so forth. Then you have a wasiya, and the remainder will be distributed according to the Islamic law of inheritance. Obligation to Allah is a list of it. You know, you have not paid the zakat, you have the chance to write it down in your wasiya. So this is why the wasiya becomes very important, that you do not know, we do not know when our death is going to come. So if we have loan, we haven't performed Hajj, we're postponing it for whatever reason, but if you have a will in there, it's going to take care of that. So we are now looking at a list of the obligation that you must satisfy here. One thing is that I search and I ask a lot of scholars here, there is no fidya for missed salah. I don't know where this emerged from, maybe a social and cultural thing, but I asked the scholar, I asked the Mufti, give me one hadith somewhere. I found one hadith which says a Sahaba came to the Allah's Messenger and said, Ya Rasulullah, I miss my prayer, what do I do? And he says, perform now. So that is when you are alive. When you die, there is no fidya for that. Hopefully, you will make it up in your lifetime. The salah is such important thing. I don't want to dwell into it, but I say Quran repeatedly say about salah, salah, salah. And you cannot be a Muslim if you're not performing a salah. In the hadith collection by Ahmad ibn Hanbal, he says a person can be a Muslim if they are committing all kind of evil, adultery, stealing, drinking. But if a person who abandoned the salah is no longer a Muslim. It's a very authentic hadith there. Anyway, so we have this thing that we want to make sure that is taken care of. Now comes to debt to the people. Then we owe it to the people. And one of the top on the list is the mahar. When you get married, sometimes you say, I'm deferring it, I will pay it later. But paying it later, you may forget. Paying later also have a problem. Let's say 10 years ago, you said, mahar is $10,000. 10 years later, you cannot give to your wife $10,000 because the time value of money has changed, and $10,000 is not going to buy the same thing as they buy 10 years ago. So I consulted the chairman of the 5th Council of North America, and he is also the chairperson of ICNA, Sharia Council. How do we solve this problem? He said, at the time of the marriage, you say $10,000. Understand what was the value of gold at that time. Let's say it was 2 ounces at that time. 10 years later, 2 ounces of gold, maybe $20,000. That's what you have to pay to your wife because you deferred it, and she's not going to get the benefit of it using 10 years ago, now it's using later on. The other thing is that also highlighted here is the donation. We all know we want to help our masjid, our school, and other things. But when we make the pledge, who are we making a pledge to? Not to the masjid. We're making a pledge to Allah Azza wa Jal. So if you don't pay it, you're responsible for it. Masjid does not have the capacity or the manpower to go after everyone who has pledged. It is impossible to them. So please, when you make a pledge, know that this pledge has to be fulfilled. It's not something that you just put it in the paper and then you forget later on. Assalamu alaikum wa rahmatullah. We were over here. I want to mention just one thing. It's very important for you to have the credibility of my work. Because without the credibility, people will not know whether I made it up everything or not. First of all, I am very grateful to Allah has given me the opportunity to do this work. Second thing is, ISNA's convention in Houston over the Labor Day weekend, they have selected my book in the Meet Authors program, so I will be given a session there. Third thing is important is that the inside pages of the book, there are 5 scholars who have endorsed the book. They have reviewed it, they have read it, they made correction, they made suggestion and everything. So what you are looking at is not one man's work. It is over 7 years working with a lot of people who have helped me one way or the other. There are people as far as Pakistan and Indonesia and China who have helped me for the drawing in the books here and the printing. So if any one of you are going to the Houston convention, my session will be on Saturday, 11:15 a.m. inshallah. Jazakallah. Now, the next thing is that we're talking about the death. The death is something we don't want to have. Allah has given us enough, so we should spend what we have. We should not follow the other people who do not have the money and they borrow left and right and is spending more and more. We Muslims do not want to do that because this is something become a liability, and I will show you what will happen. The consequences of seriousness of death. A Muslim who is killed in jihad is the biggest honor somebody can have. However, all his sins are forbidden except his debt. Allah does not forgive the debt that you owe it to the people because that's the obligation to the people. Another thing is the soul of a believer is attached to his debt until the debt is paid off. References are giving over there already. Now this is also very scary that at the time of the Prophet ﷺ, he used to ask the people if the deceased has any debt. If somebody voluntarily pay the debt, he will perform the Salatul Janazah. If not, then he will say to the Sahaba, you go ahead and perform it. This is how serious it is. And the will is the way to prevent from these things happening. Because even if you have a loan, because it's necessary, sometimes you have rent and you may have taxes, you may have meher you have not paid and other thing. So your will is going to discharge all your debt and save you from these kind of things. The first category of heirs, this is a very simplified model. There are 3 categories. The first category is, which is mentioned in the Quran, is called the primary heirs. They have their fixed share and they have indicated in the Surah 11, 12 and 176. And also there are 4 males and 8 female. Before Islam, female has 0. Now the female are 8 and males are 4 in here. So Allah Azza wa Jal has recognized the importance of having the share to the female and abolish the practices at the time of Jahiliyyah. This is a list of the 4 males and 8 female here. All of these things are in my book, by the way, if you want to read it in detail. The second category is called Asaba. Asaba is the male lineage of the deceased, male descendant. So we have, their share is not fixed. It depends on how much is left over after the distribution of the first category. If something is left over, then the second category will get it. Otherwise, it's not available to them. The third category is called Dhul Arham. Presentation. The idea? Okay. So, this is a very simplified model of the inheritance laws in Islam. And as I mentioned before, there are three categories. The first category is called Zul Furud, which is mentioned in the Quran, ayah number 11, 12, and 176. And they are the first one who get the share. Then I mentioned there are 4 males and 8 female. Okay? Then just a list of those people who are there. They are, by the way, if you have the copy of the Quran, you go to Surah An-Nisa, which is the 4th surah in the Quran, and look at the 11, 12, and 176, they are mentioned by name there, and their shares are giving in fraction. So it's not a mystery, it's not something difficult. You can find it very easily in there. So in there you have the father, husband, brothers, and grandfather as the male. Female is mother, wife, sisters, daughters. The sisters on the father's side and sisters on the mother's side. Then you have the grandmother and grandson's daughters. So they are mentioned in there, all of these things. The second category we have is called Asaba. Asaba is the male relative of the deceased. And they do not get a share if all the money is consumed by the first category. Whatever is left over will go to the second category, which is the male relative of it. Those who are not mentioned in the first category, they will go to the second, provided they are the male relative. Then you have, this is called, they call secondary, and the share is going to vary depending who gets what share. So if there are no 8 female and there's 4, there's something is left over, they will come to this category, and this category will then distribute it to the male relative. However, there are rules, and rules and regulations are already is indicated in the Quran and Sharia, and the scholars have worked it out. Next thing is the last category, which is the called Zul Arham. Arham is the plural of Raham, and Raham, you already know the mother's womb. Those who are descendant or coming from the womb of the mother. So they are also entitled to it if there is nobody in the first category or the second category. Because that's very important, because the first and second category going to, if they're going to consume the total wealth, there will be nothing left over. It is very rarely that somebody doesn't have a father, mother, husband, wife, son, daughter. It is very rare case, but the Quranic law of inheritance covers the whole domain. They don't leave out anything, because there could be one situation that need to be covered. So 95 or more % of the people perhaps will have the first and second category only. I have given a list of here that the people who have no right to inheritance, in them all the step relationship, adopted relationship, in-laws, children born of wedlock, and let me mention it to you, children born of wedlock. If a child of zina is born, that child does not inherit from the father, but that child inherits from the mother. Because the father may not be known, but the mother is always known because she gives the birth. So these children will inherit, but if the father admits that he is his child, then he will get the share. Then we have the slavery, which is not an issue. Non-Muslim don't get a share. And this is very surprising, which I spent a lot of time trying to solve this problem, that Muslim male are allowed in Islam to marry a woman from Ahle Kitab. Ahle Kitab are the people, Jews and Christians. So we can marry the pious woman from the Ahle Kitab. And they do not get any share in Islam, because inheritance is based on faith. and a Jewish and Christian wife do not have Islamic faith. This is a decision by the scholars. Now we have a problem. The state law says you cannot exclude your wife from your will. And if you do so, the court will override and give her as much as 1/3 to 1/2 of the share. So I have worked it out 4 ways to handle this. Now I'm not going to talk about my book, because because if you ask me what are those 4 ways, then we will be here all night. Therefore, I refer to you, go there are 4 listed over there, please, because I'm going to just refer to something where you can find additional information that I'm unable to give it to you in a limited time. So please be patient and be kind to me. Jazakallah. Now, there is a number of misconceptions in Islam by some practicing societies where they think that they can exclude the people because one reason or others. Newborn babies cannot be excluded, unborn fetus cannot be excluded, rebellious and disobedient children cannot be excluded, divorced wife cannot be excluded if the iddat is not over. If she's still in a iddat, she's entitled to. When husband dies, when she's in the iddat, she gets that. Then mentally and handicapped physically, they get a share. Missing relative and those who kept in a war, they also get a share. Those who are in the prison, they get a share. Very wealthy get a share. Very poor get the share. The Islam does not get. One of the category is that a lot of people, when their children, mainly the son, is disobeying the father, and the father in the fist of anger says, I'm going to disown you and you will not inherit a penny from me. That's not allowed in Islam. If Allah has given them, you cannot override them. And you do not say that this is my favorite son because he helps me out, he listened to me and all that, so I'm going to give him a more share than the other. That's going to be violation of the Islamic law. May Allah forgive us if we do that. So, now come to the final section here. What is the conflict and how we can solve those? So, I mentioned it to you, the women from the Ahl Kitabs. The court says she should get a share. Islamic law says that she should not get a share. Remember the hadith of Sa'd ibn Waqqas that I just told you a while ago? That the Prophet ﷺ said, you can take 1/3 of your wealth and give it to those who do not get a share according to the Sharia. So the 1/3 of the share, you can take a portion of it and give it to your Jewish or Christian wife to satisfy the state law. Then there is a problem to that. The share she's going to get is going to be smaller what the state allows them. So we have a problem. How do we go solve the secondary problem? Again, for the sake of time, I have given solution how you do that by legally binding on a woman from the Ahl Kitab as your wife, so she cannot challenge you in the court later on. Okay, so we can do that. Same way the non-Muslim children, parents, adopted children, they all can get from 1/3. 1/3 is on our disposal. We give it to anyone we want, but we're not going to give it to those who are already getting a share, so they cannot get a double share. This is very important and is very unknown to the Muslim community, because the USDA, lots of people think it is the United States Department of Agriculture is stamped on the meat. It's not that. Acronym is the same, but it stands for the Unified Simultaneous Death Act. The Death Act says that if closely relative people die in a common accident and they die all together, and it cannot be determined who died first, how are we going to handle their inheritance? Usually, if there are A, B, C, D, 4 people, when A dies, his wealth is distributed to B dies, go to C, C dies, go to D, and so on. But the state law says we're really not going to distribute, it's too much for us administratively. So what we're going to do, we think that nobody's going to inherit anybody, they're just going to go to their relatives. So A's wealth is going to go to A's relative, B to B's relative, and so on. Fortunately, this is how the Islamic law also works, that when you cannot determine the sequence and you do not know who died first, then you follow that. So we don't have any problem with that. However, we do have a problem, another thing in the USDA, and that is 120-hour rule. The rule says that if two people, closely relative, let's say husband and wife, one dies in a car accident right on the spot, and the second one died within 120 hours, they will be considered as if they died together. Well, that is a violation of Islam, because if A died on the spot and B is still alive, B inherits from A. So we have a problem over here. And how do we go around solving this problem? Because we want to have a will that will be compatible with the state law as well. One very late night, I was going through the internet and looking at, in detail, the Uniform Simultaneous Act. And I come across a name of a executive person who handles this law, and he's a lawyer. So I wrote him an email. I'm saying that I'm writing a book, I'm a Muslim, I have a problem with this law here, can you help me? He immediately answered me and he says that yes, you can. You, in your will, write a waiver, that you're waiving the right here, and 120-hour rule will not be applicable. So I said, that's good, but I need the reference in my book. I can't put anything in my book without the reference. So the people can go on actual source and can say that. So he sent me the reference. Then I asked him, could you give me the permission to include in my book so you will not sue me later on using your data? And he sent me the email saying, you know, you have the right to use it in your book, alhamdulillah. Now, there are some issues that are created socially and culturally and because of the ignorance. So, if you marry Islamically only, state law does not consider that as your wife. So if you die, according to the state law, she's not going to get anything because they don't recognize the religion is a secular country here. So I don't know why people would just marry Islamically. I am the president of the Islamic Association in Richmond, Majid al-Falah, and I have the license from the state of Virginia to perform Islamic marriages. The people call me and they say, can you perform the nikah? And I say, sure. Do you have the paper? They say, what do you mean? I said, you have the permit from the state. And then you have to have a photo ID. I want to know you legally in this country, because I'm required all these things from the state law to check and make sure that the wedding I'm performing is meeting the state requirement, because later on if you have a problem. So if you marry Islamically and the man disappears, the wife comes after me because I performed the nikah. Now I'm in trouble. She will drag me into the court and say, this is the guy who performed my nikah, and I don't know where my husband is. So I didn't do that. I told them, look, even the countries around the world, Muslim countries, they have a qadi, they have a register, they write everything and they register with the court. So why do you want to do Islamically? Many people say that we are allowed to marry up to 4. So now this is another problem in this country, because they only recognize one wife. But ironically, in this country, non-Muslim can have one wife and they can have dozens of girlfriends. It's a joke. You're not taking the responsibility. When Islam says you can marry up to 4, it means you are responsible for all 4 of them. And many of the Muslims who are not very well versed in the Quran, they do not read the ayah beyond where it says you can marry up to 4. They don't read the next ayah. You know what the next ayah says? 2 conditions. One condition is that you must treat them equally. And the second condition is, it's not possible for you to treat them equally, so it is better for you to have only one. Check it out. It's in the Quran, but people just don't read it and ponder over it and understand. Well, for most people, 1 is enough. 2, You're looking for trouble sometime. Okay. That's true. SubhanAllah. Okay, same thing happened with the divorce. If you divorce Islamically, she's still married in the eyes of the law. So don't do that. I mean, if you really don't want her, just divorce her so she can go and marry somebody else legally in this country. Cases of more than one wife, there's no state problem, and there's no distribution in inheritance. Inheritance laws in Islam says that if you have more than one wife, their inheritance will be equally distributed among them. So we're okay there. Property ownership is a very complicated and detailed process, and I'm not really going to go and trying to explain you everything. But I would tell you that if you own a property, a house, then check your deed carefully, whether the deed is in your name or is a joint one with somebody else, or your wife or your children or whatever, and find out whether they are one of these three categories. The first category, tenant is common, is okay. Why is it okay? Because if one person dies, his shares go to his wasiya and her portion goes to her wasiya. But the joint tenant says that if one person dies, the survivor takes all. Islam says no, it belongs to the husband. How can you take all? So we have a problem there, and I would say that if somebody need consultation with me, and by the way, I don't know whether I mention it to you or not, the second author of this book is a lawyer. She is a practicing attorney in Chicago area, Oak Brook, and she is my chief consultant on these matters. So we always go back and check them. So if you need any help with your property, and make sure that it is rightfully according to Islam, you need to change that legally so it will not be in conflict with the inherited law in Islam. Perhaps people don't know that the American 50 states are divided, and 19 is community property state, they call them, to marriage couple. They say it doesn't matter whose name is on the deed, it doesn't matter who paid for it, they both get 50-50. And then if you have the debt, then they both own the debt, no matter who borrowed it. If one person dies, then the other person takes all. But you can have this thing change because it's under the legally your control, so change in the deed, and the deed will be a legal binding document to say that you paid all of it, so the wife is not entitled to the whole thing. But in many cases that I will cover later, that a wife is also working. She's paying the mortgage bill, she's paying car loan, she's contributing for the household expenses. So it is unfair that everything you own goes into your will because she owns part of it, maybe 50-50. So you want to make sure you take care of. Again, this will not come under the simple will. It has to be a customized will that requires some changes and consultation with me. So the rest of the state, beside those blue, which are mainly the West Coast state, that says, no, this is not fair. You know, you're going to have to prove that who paid for it, whose name is on the deed, okay? And how, whether it's going to be 50-50, 40-60, 30-70, 20-80, whatever they would do. The will is not to be recorded if your property is tenancy in common. And this is the way you want to go in. You want to change that in your deed. So you'll know that the property is not going to go by someone who is not eligible according to inheritance laws in Islam. This is the biggest problem that I had to tackle. Everything that you see here has a beneficiary. So if you have, let's say, 401k account, or you're working, you know, your employer gives you that, or you have an IRA, then you have to have, by law, a beneficiary. Now, that means that if you die, the beneficiary will take over all the money. That is wrong, because this is your money, it should be in your will. So we have a problem there. Same thing is the problem with the insurance policy. Now, the scholars have debated about the legal, illegal, haram and halal about the insurance, life insurance, and they argue. until the car comes home. And I don't want to get into it. I want to look at the insurance policy, proceed according to inheritance law. Inheritance law says that when you die, everything in your possession is your estate. So when you die, is the insurance policy in your possession? No, it comes after your death. It may come several months late. You know, the insurance company don't want to pay. They're going to investigate to make sure that, you know, it's a legitimate claim on that. So, from point of view of this inheritance law, that it is not included in your estate to be distributed. However, if the wife or whoever is designated, maybe wife died and husband policy, so they get the money. What they do, they should check with the scholar. I'm not going to dwell into it. This is going to be beyond my capacity, and it does not going to serve any purpose for which I'm writing this thing here. So now, here is the question that I talked to you earlier about the working couple. Of course, if the wife is contributing, because both husband and wife working together, then it is not fair that you take all. She is also entitled to what she has contributed towards the assets you have. So you have a way of 4 ways of solving this problem. Again, my apologies, is in the book in detail 4. Because why I give them 4? Because one situation may not fit everybody. So I gave you 4 different reasons how you can go. Mainly problem that is very scary for our sisters is that if they are working and they are housewife, okay, they're not working anymore, and they have children. So the Islamic law of inheritance says that she gets only 1/8 of the share. And she's going to say, am I going to move out of this home? 1/8 is not going to buy me even enough money for renting a room or apartment somewhere. What am I going to do? Well, good news, I have the solution in the book, follow them. And it is really based on Islamic ethical and legal procedure that how you handle the situation. This has nothing to do with the state law, okay? The state law doesn't care who you give your money. Now, a long time ago, I was reading a news that somebody died, left $20 million to give it to cats and dogs. And the state court said, we don't care. That's okay. Well, this is a good advantage for us to now follow the Islamic law, give people whatever we want to. It's a plus for us. This law helps us out. Okay, then there are questions about the Social Security survivor's benefit. See, when you die and you are on Social Security, it means you have paid for the Social Security, 10 units, and then when somebody dies, the government gives you. So what happened? At the time of our death, this money was in our possession, just like the insurance money. So that is not in part of our estate distribution, but it is a benefit that comes, not lump sum, it comes every month. That government is helping it. It is not something you own it before your death. The lifetime gifts and charitable trust. The gifts, you can give it to anybody while you're still alive. So there's a difference between the gifts that you can give in your life, and when you die, then you cannot give any gift because it has to be distributed according to Islamic law, except that 1/3, you can give it to anyone. But just one hadith I want to relate to you. When you give a gift in your lifetime to your children or your relative or somebody, it's a very famous hadith. Nu'man bin Bashir, radiallahu anhu, when he was a young child, his father says, I'm going to give my son some wealth. And Nu'man bin Bashir's mother says, I want Rasulullah sallallahu alaihi wasallam to be the witness, because I don't know, you change your mind later on. So Nu'man bin Bashir and his father went to Rasulullah sallallahu alaihi wasallam, and he said, Ya Rasulullah, this is my son, I want to give you this thing, and I want you to be the witness. Rasulullah sallallahu alaihi wasallam asked, do you have other children? He says, yes. Are you giving the same to your other children? He says, no. Rasulullah ﷺ replied, I do not want to be a witness in injustice. Take it away. So if you have somebody, you treat them equally. Islamic law of inheritance says the son gets the double, only in wasiyah. In the lifetime, is no such rule that the son has to be double of the one. With the one exception is that if your children, some are poor and some are rich, now you can justify that because somebody needed more help than the others. So this is okay to do it. But intention is important. Remember the hadith number 1 in Bukhari, related by Umar ibn Khattab radiallahu anhu, innama a'malu binniyat. So your intention is important, whatever you do. It's a long hadith there that somebody who marry for something, they're going to get the reward that. Somebody make a hijrah for whatever reason, they get that. But if their intention is to please and fulfill Allah, then they are rewarded. These are the basic requirement that every will should meet. If you leave one of them out, somebody can challenge you and say the will is not valid according to state law. Okay, I have listed them over here because I'm not going to refer to the book. It's over here. You have to be 18 years old to the state laws. There could be a lower cases that I have a footnote there in the blue at the bottom of the slide, that a person must be of sound mind and writing a will with the free will, nobody is intimidating it. It must be in writing. Holographic will is nothing but somebody who write a will in his own handwriting. Some state recognize that, but the majority of state do not recognize. And it is not a good idea to write your will in your own handwriting. What if you want to change it later? You're going to write all over again? So it is better to have a computerized will. You make changes, print it, and notarize again. A much easier life. The opening and statement in the will should be declaring that this is your will and nothing else. If it doesn't have that wording, people will think it's not a will. You just wrote something. Then you must have some beneficiary. The state says you're writing a will, you got to have some wealth to distribute. If you have nothing to distribute wealth, why are you writing? So we also have a very important person here. This is called the executor of the will. And you have second important person, if you have the minor children under the age of 18, a guardian. The guardian plays a very important role. In cases where the husband and wife both died in an accident, they must have a guardian who's going to raise their children Islamically. The book has 2 chapters in there and tell you the characteristic and what you should look into an executor and guardian before you select one or the other. You must have 2 witnesses. Some state require 3, but 2 witnesses are the one that cannot be the beneficiary in your will. If they're getting a share, they cannot become the witnesses. Now, if somebody getting a share, they can become the guardian and executor. That's okay. Then your signature must be signed in the presence of all 3. You, your 2 witnesses, and the notary public. Notarization is not required, but the lawyers always recommend to have one. It makes things easier. It goes smoothly in the court should you have any problem. It is not required to file your will in the court. You could do that, but if you change it, you're going to have to submit another one, and some state will charge you a fee for doing that. So, we're coming to the last portion of it here. The Muslim in America have the choices to write a will. They can go to Islamic Venture website, download a file from there, and that's your will. The problem is that will has no name on it. Who endorsed it? Who reviewed it? Is it meeting the state requirement? Is meeting an inheritance requirement? You don't know. The second thing is you can go to the stationery store and you find a printed will by like 1 or 2 pages, you fill in the blank, but that doesn't take care of your Islamic law of inheritance. The third thing is the online wills are available from the lawyers, non-Muslim lawyer, Muslim lawyer. but that also doesn't have the Islamic law of inheritance distributed. Then you can go to the lawyer, have a customized will. Well, the problem is the non-Muslim doesn't know the inheritance law in Islam. And a Muslim lawyer, many of them, they didn't study the inheritance laws when they went to the law school in this country. So I don't recommend that you use any one of them. So your choice is the right choice. There is a will that has been written up through the 7 years research, endorsed by the scholars, meet the state requirement, meet the Islamic requirement, and that's your safe way to do it. Just to show you, the Islamic will template that we have has a preamble. The Islamic will is not only about money. It is about your faith. You declare your faith that I believe in Allah and His Messenger Muhammad sallallahu alaihi wasallam. You say that in your will. My burial will be according to the laws of the Islam, and you will not do anything that are wrong in there. So this is where it prevents from people to do it. It's also make sure that you have fulfilled the Islamic law of inheritance in your funeral and burial. The second thing is already talk about your debts and obligation. Third thing is you assign your executor and guardian. Then you have the last chance in your life to give something out of 1/3 to Islamic Society of Baltimore or any one of your choice or your Islamic school. Then remainder will be distributed. So this is show that. Here is what? I'm not here to sell the book. The first thing is, you don't have to buy my book. The first thing is that to make you aware of it's important that Islam requires you to have a will. Second thing, if you don't have a will, the state will take over. That's a risk and danger you don't want to take. Third thing is that if you do not satisfy the Islamic law of inheritance, I showed you the slide, what will happen to the people who die in death. And then also show you that the obligation are there that you have not fulfilled, so you'll be accountable in the hereafter. A Muslim, we do not expect that they want to put themselves in a jeopardy and take all this risk. So I'm here to help. I do the consulting for those people who have very different situation or not simple one. Then I can have a one-to-one consultation with them, inshallah. If you want to order the book, the information is here. If you don't have the money, you can take the book, give me the name, mail the check. We are all Muslim, we trust everything. You know, remember that Surah Al-Mu'minun? One of the characters of Muttaqi is, they fulfill their promises. So if you fulfill your promise, Allah will be pleased, you will be pleased, and I will be pleased that I get my money, inshallah. So that's where we are here. Now, the other thing that we have services available. There's a situation there where people just can't read the book and do their will themselves. They need a special thing. So you can get the book and do it yourself. I can do it for your will. Or you can have the special now. You can get the book and you get the will, both, and save $50 in here. You can also get the added thing called self-proving affidavit. What is self-affidavit? See the two witnesses that sign your will? What happened 5 years later? They might moved out. You can't trace them where they are. And if they need it in the court, where are you going to find it? So what you do, you prepare this affidavit called self-proving. The same two witnesses who sign your will also sign this affidavit, and the court will accept this affidavit and will not require the physical presence of two witnesses who sign your will. Then the last thing, which is not part of the will, is your health care directive. I mentioned it to you many times. We get sick and we are not able to make our own decisions, so you should have a proxy. Somebody you nominate who will make the decision with you. If the hospital is putting somebody on a life support system and you don't want them to, so you have to have the authority by the healthcare directive to say disconnect. I don't want, let this person go now. So many times the hospital wills are running and nobody's there to make a decision. Family members are fighting with each other. Some people say, well, leave the lifesavers equipment on. Some saying, no, it's already brain dead. What are you you know, prolonging it. So if you have somebody who can really make a decision and have this document called the healthcare directive, then the hospital and doctors by law will obey whatever you tell them, inshallah. Customize well, I'm available. I have my business card over here, and feel free to take one and give me a call. I don't do anything else in my life. This is my 24 hours work. And I've been traveling around the country. I finished New Jersey, Virginia, North Carolina. I'm here in Maryland. Then I'm going to Ohio, Missouri, Michigan, Illinois, and then I will go to Texas. So this is the awareness class that people know that now you know it is obligated to have one. You have the choice to make a will that meets the state and Islamic requirement. The choice is yours whether to do or not. It's not up to me to make anybody do it. I hope that everybody will do to protect themselves and their families, inshallah. Jazakallah khair. I take the question now, inshallah. Yes. See, when I said that a 401k was a specific example of how you get this retirement and pension. You use the word interchangeably because in Canada they use pension. They don't use 401k and all that thing. They have their different laws. So whatever you have which is set aside either by your employer, or you set it aside by yourself, or your employer gives you on the top of it, then it's yours in your lifetime. So it will be part of it.
The way the pension works typically here is that it's like Social Security, you pay to it, but you don't have any. But when you reach a certain age, either you or your comparator get payments over time. There is nothing to cash out. Like similar to Social Security, you don't get to cash out.
Okay, you are right in a way. But let me explain a little bit more in detail. The way the 401k works, that employer gives you something, 5%, 2%. Then you put in your contribution before the tax dollar, so you don't have to pay on tax on it. Some companies also give you stock option, but they make a condition that if you get 100 share of that company A, only 1/3 will be vested every year. So if you work 2 years, you're entitled to 2/3. It's yours money now. But 1/3, you will lose it because you didn't stay with the company. So this is how it works. The pension is the same way that you earn. What you earn is yours. What you don't earn is not yours. Inshallah. Yes? SubhanAllah. Just the benefit of the sisterhood in your question, I'm going to repeat it, make sure I get it right. So when you're talking about the beneficiary, and the money goes to the beneficiary and it's yours, you're gone. There's no way you can force the beneficiary to put it in your estate to be distributed according to the Islamic law. So what are you going to do? There is a number of situations where you can have options to make sure that the money going to the beneficiary diverted back into your estate. There is a letter of wishes, which is a template in my book, that you sign it and sign your beneficiary, that beneficiary, whether your husband or wife or children, will put it back in there. But that's a non-binding. Letter of wishes is your wish. They don't have to comply with it. Then there are other legal documents that you can write, which is, I have a template in there, which has to be signed by that person to say that money is going to go back to your estate. And that will be binding in the court. So this is how you take care of it. There are instrument or document that you can execute in your life to make sure the money is coming back to your estate rather than going to the beneficiary, because the law requires you to put somebody's name in there. Inshallah. You have a question there?
Yes, I do. You said that the book is $99, right? But the forms are not electronically available. So we have to fill those forms by hand. And then so the second thing is, if you go by the get simple bill is $150. We need to provide you the information and then you give the bill or how it will work.
Jazakallah. That's a good question. The question is that if you buy the book, then you fill out all the information by hand in your book, right? And then the second thing is that if you give me the information, then I'll save you the effort to fill it out correctly so you don't make any mistake. And also, it is flexible enough because sometimes you yourself, even though I have given very clear instruction in the book, some people will not be able to calculate the share in fraction. Most of us deal in percentage and decimal. So they don't know. If you say, well, I want to give 1/3. 1/3 is mentioned in the Quran. But many people will say, what? 33%. It's 1/3. But 33% is wrong because it's not equal to 1/3. 1/3 is equal to 33.3333. It goes forever. So when you round it off, it's not going to add it up to 1. So you're going to say, what am I going to do with the leftover money? So I make sure that I recalculate in such a way that everything added up to 100. It's not more, it's not less. And you just have to review it, print it out, sign it by the witnesses in front of the notary, and it's done. You put it away. And then one thing I wanted to mention to you, what happens if you want to change the will later on? How do you do that? If there is a simple change, you use a legal document, which is a very short note called codicil. The codicil will be attached to the will. You said, well, I have a birth of a child. I want to add the child into my will. So then you put it into the codicil. You don't have to go and revise and make changes in your original will. But if there are many, many changes in there, then it is better to rewrite it, because too many changes, people get confused what's right and what's wrong. I would give those people who come to me or they read the book, I'll give you a list of it. What are the events that will require to change the will? What are the events that do not require to change your will? Mainly death, divorce, marriage, financial changes. You want to change your 1/3 contribution, all that. You cannot touch the 2/3. That is, Allah has that. That will stay there unless you add another inheritor, say a child or relative in it to it. Inshallah. Okay. Yes, sir. Yeah, you can fill it out by hand, because what you are filling out is your name and your signature. Everything else is already written, typed. So you have to have your signature by hand, and those things that you are filling it out, they are left blank. That when you find no blank in there, you can't touch that. I mean, leave it the way it is, because if people start making changes in the will document, they might delete it, a conflict thing with the state law. So I don't recommend that I may do it. I'll tell you whether in 1980, Dr. Manzar Kahaf, he's still alive by the way, he works in Qatar, he's a professor of finance there. I have been consulting with him over 2 years by email and phone call. He wrote a will in 80 that became Isna's will. People start copying it, modifying it. In Urdu, if you understand that, us will ka huliya bigad diya. They don't know what the heck it is anymore, what's right and wrong. People start making changes in it, and the legal things has their own vocabulary. You can't change it to your everyday language. If I do that, then it has a different meaning in the court of the law. So yes, you can fill it out, those things. Those who didn't hear the question is that the brother is asking if somebody has three children, 2 girls and 1 boy, can he take 1/3 and distribute it according to the Islamic law or not? Like I said before, it is not up to you to do the distribution. The distribution is already defined in the Quran. Why do you want to do that? Because already Quran says in ayah number 11, Surah An-Nisa, that the son gets a double of the daughter. So if you have 2 daughters, okay, what you do is that depending on other relative, it's not going to be 1/3. Why is 1/3? You have 2/3 that is to be distributed. 1/3 is you give it to those who are not your relative. Your son and daughters are not entitled to get anything from the 1/3 which is optional under your control. The 2/3 is already decided, and 2/3 is calculated. So if you have 2 daughters and 1 son, the share is going to be decreased as opposed to if you have 1 son and 1 daughter. Why? Because if your mother and father are alive, they get 1/6 each. So you take 1/3 away. So 2/3 will be then distributed to husband, wife, and other relative that are there. So it is a very comprehensive law. In here, I have shown you 4 ways how to calculate the share. You can calculate mentally, you can on pen and paper, you can use computer or whatever way. Inshallah. Could you hold on one question because I have something from the sister to answer first? Is that okay? Okay, Jazakallah. The question I have here, if an adult that is mentally disabled, for example, having Down syndrome, intellectually disabled, etc., has money and asset, do they need a will written? Does this change if they have legal guardian assigned by the court? Jazakallah khair. Thank you very much. Very good question. Yeah, first of all, sister, you know that the mentally ill or whatever, they're still entitled to share. You cannot deny them because they are insane or physically disabled. You can't do that. But if they are disabled and they have mentally, intellectually disabled as well, the money assets that they need will be written in the will. My will covers another thing in there. You have 2 things here in the will. One is the guardian. The guardian is going to be the person who's going to be raising the children Islamically, paying their, for food and their living and their school expenses and everything. The other one is called a trustee of the children. The trustee is going to take care of the financial thing because the court doesn't want somebody embezzlement, and that he will pay the expenses to the one who's raising the children. So in case you have a disabled child and he has the wealth, you have a trustee or a legal guardian, and it will be assigned in your will. You don't need to go to the court for that. This is what the beauty of it is, that we take care of everything and try avoid the court. In my will, alhamdulillah, the people who have looked at it, they say there's no way anybody can win in the court. You know why? Because I looked at the Constitution of the United States, the 4th law, and it says that the courts are not allowed to entangle and rule on the religious matter. And what I did, which I didn't find in many of the wills that are flying all over, is called arbitration clause. The arbitration clause says that if there is a dispute in this will, then a body of Muslim scholar will rule over it and it will be binding on the court. So keep the court out of it. And you can have the mediation process, arbitration process to solve your problem, which is Islamically right to do it. Why pay hundreds and thousands of dollars to lawyers when you have the case in the court? Nobody wins except lawyers, both sides. And once you're done, there's nothing left over. Lawyers have taken most of it anyway. Yes?
If you allow me, I have 2 questions.
I hope that question is very general to everybody. Very specific question you can be later on. Okay.
One question is related to my own family, one related to my friend. The question is related to my own family that I understand that sons get double share of daughters amount. But in my case, I have 3 daughters and no sons. So how was it distributed?
It's a good question, and a very informative question for people, because this can happen. I myself has 3 daughters, no son. So it is not a unusual thing. Okay, great. So you are saying what's going to happen to distribution because no son. But let me ask you another question before I answer this. Do you have father alive? No. Okay. If father is not alive and there's no son, then your brother and sisters, full-blooded brother and sister with the same mother and father, they are entitled to a share. No, this is not going to happen that way. What is going to happen is that the share that's left over from the daughters, there is no double there because you have no son there. Okay? If you have a son, then son gets a double. The beauty of Islam is that it gives the women, a sister in Islam, an elevated rank. You know what that means? Is that the paradise lies under the foot of the mother, not the father. And here he's saying is that the daughter share is determined first, and then you double it and give it to the son. So this is how you do. You don't have a son, so there is no double over there. But your brother and sister then will enter into equation and they will be entitled to share. And this will be a little more complicated than a straightforward. Because many people who have the son, the brother and sister, uncle, aunt, nobody come into play because they don't get any share then. The only person that is a very common situation, you have mother, father, husband, wife, son, daughter. Because if you have these, all others don't get anything. For example, if you have father, your grandfather doesn't get anything. If you have mother alive, your grandmother doesn't get anything. So if you have a son, son's daughter doesn't get anything. Or son's not going to get it. The grandchildren are not going to get it. So it's a very simple way of doing it, inshallah. How can you prepare the will? Okay. I'm going to have to mention is that I can do the consultancy, do it for you, or you can read the book and do it because it explained there clearly how to do it. Okay? 2 ways to do it. The book or me. Or you can ask some scholar how to do it, inshallah.
Second question, in my friend, one of his daughters got married to a non-Muslim, and that husband did not convert to Islam, and the daughter is still staying in Islam, but I don't know that they're practicing now. In that case, the daughter got married to a non-Muslim, can she get any inheritance?
Alhamdulillah, what a loaded question. Were you asking me to rule on the Sharia? First of all, a Muslim female cannot get married to anyone except a Muslim male. That's the law of the Quran. There is no scholar who is going to dispute on it. The only exception is for the Muslim male to marry a Ahl Kitab woman. That's it. But they don't get any share anyway. So she is not legally married to her Islamically. So I don't know whether they both are Muslim. One violated the Sharia to marry somebody who is now supposed to be married it because it's illegal to marry a mushrik or a kafir for the woman in Islam. But you have the flexibility. The flexibility comes that according to the Sharia, she doesn't get a share. But according to 1/3 under your control, you can give part of it to her. Islam is really provide the solution for many, many situations, and it makes sure that you're not stuck and don't know what to do it. And if you're stuck, different people are going to do different things, and that's going to be a chaos. Yes.
Very generic question. So you've gotten the witnesses, you signed it, you now have a copy. What do you do next? Do you send a copy maybe to ICNA, to ISNA, do you keep a copy and you're under the mattress? I mean, what is the right way to do once you have this thing signed, so that where's the will? You know, what do you do?
Jazakallah khair. The question is, when you write your will, sign it, have witness, what do you do with it? Where do you keep it? Okay. I would not advise you to put it under the mattress, because this is the first place somebody who wants to steal your money, valuable, will look what is under the mattress. What I'm saying is that in the will is stated that you sign 3 copies. 1 copy will be with you, because you are the testator, you are the will writer. Okay, the second copy, you give it to your spouse. In your case, you give it to your wife if you have one. If you don't have one, find one, get one. Inshallah, because you know, this marrying in Islam is not just optional, but the Rasul said, "Man anagha rabi an sunnati laysa minni." The one who does not marry is not from my sunnah, is not following the sunnah. But there are exceptions in Islam, because somebody just cannot physically marry to someone. But I'm saying is that one is in your possession, one you give it to your wife, and the one you give it to your executor, because he or she is the person who is going to take over after death and carry on your burial and your funeral and distribution of everything, custodian of children and everything by law. So that's how you take care of it. Okay?
Can you assign the executor to any organization like the ISB or any other organization?
Executor cannot be an organization. It has to be an individual. An executor can be anybody. Anybody. The one who's getting a share or the one who's not getting a share. Whether it is your relative or not relative. Whoever you trust and know he's a practicing good Muslim, then you make him an executor. And read the chapter here that will tell you what to avoid in selecting an executor, because that is a very important thing. If you make a mistake there, then it's not done correctly and you've selected a person. Many times you select a executor and you didn't tell the person, hey, listen, I put your name in mine and here is your responsibility. Are you going to willing to take it? It's going to require some of your time. You're either willing or not. In some cases, that is okay that the executor get paid from your estate, from your assets, if he wants to. If he doesn't want to and is doing fi sabilillah, that's even good. You could do that. Okay, here's my thing. This is you here, so now we're going to write it down. You have book plus will. That's what you want for this. Okay. All right. We'll do this. You take it. You get a book, and I will do your will, because I have your phone number. Later on, I get your email, and I'll do everything for you. Inshallah. Yeah, sure. In my will, let me answer that question. This is a good question here. The brother is asking here, if you have a second executor in case the first one unable, died, or not available. I have 3 executors in my will. The primary, the secondary, and a backup. It's already explained there. We covered that situation. That's okay, brother. It's good to have joke. Be smiling and laughing within the hudud Allah. Allah has given you thing to be happy, inshallah.
Just one point of clarity. You're saying if we have sons, then my brother and sister don't qualify for the
Yeah, that's correct. Or your father is alive. If your father is alive, your brother and sister don't get anything. If your son is alive, then also they don't get anything. Because the rule is, the closer relative to the deceased are entitled to first. So the brother and sister in the presence of son, they are distant and the son is closer to you. I'm sorry. Okay. This is also again a question the brother is asking here, is that if you have two property, you live in one, for example, and the one you are renting for business or whatever, okay? So, what is your estate? The estate is total sum of the two because you own them. So whatever the financial value, monetary value it is, that will be things. So let's say you have a $300,000 house and you have a $200,000 property, so your total asset is 500,000. And assuming that you don't have any bank account, a stock option, and annuity and all that kind of a business thing, then that is become your total asset. So the property is not itself, but it's the value of the property that in terms of money is decided in fraction how to be distributed. So the question comes in that if you have a property and there are 4 people entitled to get a share from the property, how are you going to split the property? Physical property cannot be divided. So again, the solution is in my book. I'm sorry, but it isn't there. There's 4 ways you can do that, it's mentioned in there, because there is no way you can divide it. One option will be obvious, will be to sell the property and give the share from the money you receive by selling it, inshallah. Okay.
One more very generic question. So you move around the country from place to place. If we need a consultation, do we do it through the internet, or do we just communicate through email, or set up a will, and how does that work?
Yeah. The question is, I move around from state to state. How are you going to contact me? Yes, I move around from place to place. But if I move out of the world, then you cannot contact me. But if I'm in the world, internet, phone, take my business card, leave a message, I'll get back to you. Okay.
So we want to consult you.
I check my email every half an hour. And you text me, it will be right away. Fastest way now, the technology make the life very easy, right?
I know that, but a lot of people like to talk face to face. So is there like
Okay, in that case, depending where you live and how complicated is your case, that will dictate whether we need to meet face to face or not. In many situations, like 90% or more, I can take care of over the phone or internet. Unless you have a very complicated case that will require some legal action in presence of you and me.
say face to face over the internet?
Yeah.
Like,
If you are in locality and you can come to me, then that will be great. But what we do is the first step, that you do the consulting with me, okay? Then I will determine whether we require face to face or not.
no, I mean face to face over the internet, like through Skype, through other types of means. Do you do that, or it's like just email?
I would say that the phone call and the email take care of the most of the thing. But, it's a good idea, think about it, to use the other media to do the consulting and talking to you. That's a great idea. See, I'm just getting it started because the last 7 years I was just immersed in writing and solving problems. Now that I have the book, I'm going to develop an internet site where you come in and do your will online. That would be great for the simple will. The other one will be that I will provide you a way how we can get the consulting and face-to-face using other medias, inshallah. So everything is going to come, just give me time. Inshallah, Allah will give me the time, I'll keep on working. Like I said, I'm not done with this thing. Writing a book on one thing, and it's going to be locked up all the knowledge in there. It is my responsibility and it's my privilege that I get this word around to all the Muslims that I can get to in different states and cities. That's my mission is.
Like you said, there's some special cases that probably the book will not cover, so then
Yes, if there is some non-simple case there, then it will be a cost of consultation. And we determine the cost initially on the phone call, inshallah. Okay, any more questions?
You have the template, if I'm interested, you have a template that will give you all the answers of your questions. And you, based on that, you will prepare the
Yes, that's a good question. If you want me to prepare well, I'll email you a template.
Yeah.
You fill it out and I'll do the rest for you, and I'll mail it back to you, a PDF file you can crunch. PDF file is a good thing, it can be printed on any computer. Otherwise the fonts changes and it doesn't look, the things don't look right. You have the last question, right? Somebody, you do it.
Consultation fees, do you charge by the hour or how do
See,
you
I don't go by the concept of the lawyer, whether they help you or not, their clock is running the minute you call them and they say it's going to be $300 an hour. I mean, we don't do that thing. Based on how much time we spend, it's going to be a lot less than what the lawyer is going to charge. And you determine that. If your lawyer is charging $300, I'm probably charge you half of that.
average cost for consultation?
Huh?
Is your average cost for consultation?
No, there is no average yet because I've not done much consultation after publication of the book and giving the seminar around the nation. I haven't done that. So when I have more people here, then I will know the average. Average means I have cases, then I can average, but I don't have any yet data built up to figure it out what's the high, what's the low, what's the medium. Okay?
You don't have a staff, you just on your own.
Yeah, I have a staff. A staff that know as much as I know, and that's my wife. 7 years she watched me. What I am doing, she follow me everything. And she is the one who can answer the question as best as I can.